All yours, sir.
Hello, everybody. I don't know. Are we on, Michael?
Yes, you are.
Okay, I'm so sorry. So, ladies and gentlemen, this is Attorney Shaparali. Assalamu alaikum. Namaskar to all the listeners. And today we're going to talk, of course, about immigration. So many things happening on the immigration front. And we're going to also open the lines in a few minutes. And the number to the studio is 510-657-1170. 510-657-1170. We'll try to take as many calls as possible. But before I start, everything I'm going to tell you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Two bad news that we're going to talk about, the H4 EAD. It seems with an answer to the lawsuit that was placed by Safe Jobs USA, and also so many articles we are seeing on Newsweek and so many other major newspapers, they are saying basically, and the Trump administration is saying that they are ready to basically roll back the H4 EAD. That means taking it away. And also, they are also claiming that they don't need to go through public comments to do that, which is something new to me, but hey, they are coming up with a lot of things now, so we're ready for it. Now, the question everybody's asking, is it going to go away? Well, ultimately, we were expecting that, and we've been saying that, and we've been holding it for, luckily, it's been holding for a while. But unfortunately, it seems now more and more the pressure is building, and they're trying to build something to take it away. Now, the question, will there be lawsuits to protect those people? Well, everybody's expecting that. I'm pretty sure many people will be filing lawsuits. Hopefully, they will. And that might, on the other hand, protect some of the H4 visa holders. Now, the other thing that everybody is asking, what happens to those who already have their H4 EAD? Will they be able to use it? Will it stop? Well, we don't have a definite answer on this, but we are hoping that just like in DACA situations, people who have it will be able to keep it. For example, let's say you have till 2020, you might be able to use it until 2020, and after that you won't be able to renew it. So for those who want to apply, you should apply if you want to, of course, but there are, before you even do that, it's good to talk to an attorney, and if you want to call our office to do an analysis, please call us 510-742-5887. I know we are already getting callers, Michael, but bear with me a little bit for the callers, because I have to talk about two very important issues. Number one is the H4 EAD, which I just mentioned. It seems like there is a chance that within the next 2-3 months it will go away, but the question how, that's still left undecided. Now, the second issue also is...
We'll take you after that, okay? Hold on. All right?
Yes. So, yes, I think the caller... So we will be taking the callers in a few minutes, because I have to cover those topics. These are very, very important, and it covers everybody. So... but like I said, bear with us. Please hold on there. I will be glad to answer as much as I can in a minute. But right now, the second issue, for those who know about the implementation of the memo, of NTA memo, the famous notice to appear memo that appeared in June 2018, June 28. Right now, there is a publication on the USCIS website stating that they will start implementing that on October 1st. However, it doesn't seem that rigid that we were expecting, luckily. For one, they're going to apply it on a case-by-case basis. That means technically at their discretion. And number two, they are saying that the memo will not affect employment-based petitions and humanitarian applications. This is very, very important. So at least for people on H-1Bs, etc., when a denial takes place, there might not be an NTA issued for them. However, they say more guidance will come, and actually I think they have a conference today, an engagement conference happening in a few hours talking about this. So we were expecting a lot to happen, and it is happening, but we are hoping it will not be that bad like we were expecting. So that's kind of tricky to say all this. But at the end of the day, we have two major things happening. One is the NTA and the NTA memo, and also the H4 EAD. So we'll talk a little bit more about that during the show, but let me take one caller, Michael, a few callers. This is Sharp. Hello?
Hello?
Hello. Hi, this is Shah. You're live in air.
Okay. Hello, Shah. I'm Dr. Malapu from Jackson State University. I have a few questions. And
yes,
before going there, thank you very much for doing this to the immigrant community. Thank you very much.
Oh, thank you so much for your...
My priority date is April 2017 EB1. I filed it already. Mm-hmm. And then I got the EAD, and the interview is done. Everything is done, but I'm just kind of curious when the dates would become current.
That's the question. Right now, it seems like the accepting date is being used by the USCIS. That means only people who are eligible to file I-45. But in your case, you already did that. So I think your dates will become current, hopefully, if it continues that trend, by within the next maybe few months, probably in 6 months. Because right now they are 2016, and we are hoping it will not retrogress for the next 2-3 months. So hopefully you should be able to get your green card within the next 3 months or 4 months. But again, there's no guarantee on that, but this is the trend I'm seeing. Okay.
So, sure, Mr. Pirelli, my interview has been done, and the interview officer has been really very nice, and he said everything is clear. If the dates were current, I can print you the green card right now, but the dates are not current. So I'm sending your case to NBC, National Benefit Center, he said. And but my medical has expired last month. So do they issue an RFE for my medical?
Yes, they will probably issue an RFE, because this is not a regular RFE. This is an RFE because it's expired, so they cannot deny the case because your medical is expired. They will issue an RFE requesting that you do a new medical. And as soon as they do that, that means basically they're getting ready to issue your green card.
That might not delay, because my main concern is this. If it delays the thing and then it goes back to a ridiculous date, just like if the retrogression happens during this communication, I'm just kind of worried about waiting for one more year to date become current.
Yeah.
So
unfortunately, you cannot even submit the medical unless they ask for it. Because if you submit just like that right now, they might not accept it. I've rarely seen them accepting things like that in the middle. But if you already had an interview, your case is with the USCIS field office, you might be able to do what we call an appointment and go there and ask the officer if you think it's right, will you accept a new medical? Then at least you can do a new medical and have it there. And if you can insert it in the file, it will be helpful. But they rarely do that, but you can try it.
Okay. Thank you very much, Doctor.
Okay. Good luck to you. Good luck. Wish you all the best. Let me take another caller. Shapra, you're live in here.
Hello.
Hello. Yes, sir. Go ahead.
Hi, Mr. Sir. I have a couple of quick questions.
Mm-hmm. Go ahead.
Yeah. So my first question is, my employer is about to file green card in EB2. And since it's a specialized occupation, I'm also thinking to contact Mr. Sharif for filing it into EB1.
Yes.
So my question here is, at the same time, can two green card be filed?
Yes, yes. You're not filing two green cards. You're filing two I-140s. You can have multiple I-140s. but there will be only one I-485. So whichever dates will be current, you will be able to file one 485. So that means you're filing only one green card, but two I-140s. So it's not a problem. You can have as many as you want. I had a client who had three of them, one on EB3, one on EB2, and finally we got him on EB1. So it's not a problem.
Okay, that's great to know that. And actually, this particular, employer where I am about to start working, actually. So my question is my overall, I have not received the overall approval, but I maybe, I'm ready to work with an acknowledgement receipt. But my question is that in order to start the EB1 processing, should I wait till I get my entire approval?
No, because it's very independent. If you're filing EB1A, it's a self-petition. So it's not really related to the EB2. The only advantage, if you have an I-140 previously or another one, you can take that priority date. Then you can use that priority date from previously. We don't really worry about the EB2. You can have it go in parallel. You can have it one after the other. It doesn't matter.
Okay. So even if I join with acknowledgement receipt and in that specialized, because my new employer is about to provide for documentation for my EB1, they already agreed upon. So I was wondering, if I can start in parallel as soon as possible.
Yes. In fact, yes. We are recommending people to do EB1 as soon as possible because if you have a previous priority date, we can merge that, and at least we get you an EAD and file an adjustment of status instead of, even if the dates get retrogressed later, you can at least enjoy the EAD. So for people who are smart of starting their EB1, you should go ahead and get your EB1 started. And if you need help, just give us a call. We'll handle it, Sharif.
I already contacted Mr. Sharif for an intro call. He provided.
Okay, perfect. Okay, good. You should be fine. Don't worry.
Okay. I have a real quick question on behalf of my wife. Actually, she's on EAD, and in order to safeguard her employment, even though it's late, we started the form filing process. Now, my question is, her EAD is valid till 2020 April. Now, in case she gets an I-140 while on EAD, by any chance, is it going to help her, or she will still lose the EAD?
No, the problem is that we don't know how they're going to take away the H4 EAD, but it's not related. However, there's also the I-140 EAD, which Obama passed, but I've never been able to get one so far, so I cannot really tell you. But it won't really help her or hurt her. It doesn't matter really because it's totally independent. However, having the I-140 in her hand is very helpful because later on, if she gets an H-1B or something, or she goes on H-1B and 6 years has passed, she can take advantage of this I-140 to keep extending her H-1B.
Okay.
So it is always good to have the I-140.
Okay. So can she reopen the previous H-1 because it's not yet cancelled, just that she has maxed out 6 years on the last H-1B?
Yes, she can revive it as long as it was not revoked by USCIS. If it was withdrawn by the company or she moved to H4 and she has the I-140, even she passed 6 years, we can revive it.
Okay. That's what we are targeting before the actual EAD gets expired by the government.
Yeah, definitely. Give me a call since we are doing your EB1. I'll be glad to handle that one too for you. Okay?
Okay. Thank you so much. Good to know that.
Good luck to you, and thank you so much for calling. And the number to our office, 510-742-5887, and the website to check, attorneyonair.com. I also wanted to point out to people the YouTube channel. Like I said many times, it's very hard now to write articles. Things are moving so fast. So please subscribe to the YouTube channel, youtube.com/Shah Pirali Law, SHAHPERALLYLAW. Please subscribe to it, and I put updates at least twice a week, so please check it. Let me take another caller, Michael. This is Shah Pirali. You're live on air.
Hi.
Hello.
My name is Kishore.
Hi, Kishore.
Hi. First, thanks for helping the immigration community.
Oh, thank you so much for your kind words.
Yeah. I have a H1 and The validity is October 10th of this 2018 as per my I-94. My previous client has filed an extension and it got rejected. And I have applied again on this 20th September and presently I am working on receipt. My question is, as I am on receipt now, can any another company can file a H1 for me before or after my H1 validity October 10th?
Yes, but you say you had a denial, right?
Yes.
Okay, you had a denial of what? An extension?
Yes, extension.
Okay, but right now your I-94 goes to October 10th, right? Exactly,
yeah.
Yes, the company can file a transfer as long as it's filed before October 10th. You benefit from AC 21 Section 105B, which basically say you don't have to leave the country, number one, and number two, you can start working based on the receipt. So yes,
okay.
You need to move fast, get the other company to start the LCA, etc., and move on to the filing the case. And if you need help, just give us a call. We'll handle it for you.
Okay, yeah.
Okay?
So after my this validity date, no other company can file? October 10th?
Well, they can, but it's very difficult because then they have to do what we call the bridge based on a pending case. So if there's no pending case, after the 10th they can file, but it won't be a transfer. It's called a new employment kind of a new employment cap exam, but they will not be able to really file the transfer, which means you will have to leave the country, wait for the approval, come back, get your I-94 at the airport, then start working. And you cannot start working on day one. Now, let's say you file a transfer with company B, the transfer is pending, and you want to move to company C. Or you file another extension, it's pending, and you want to transfer. Then your company can try a transfer based on this pending case. It's called under the bridge situation, basically, saying that, hey, you have a pending potential H-1B which might be approved, so you should be able to piggy ride on it. But from my experience, this doesn't work that much because this is kind of one of those Obama favors which are now not really well taken. So, but it can be used at least to file it, and the results can be either an approval or a partial approval. So there are some tricks to do that, but it's a risky way, although this is available. So after October 10 now, if you don't have anybody filing anything before October 10, it's not pending. You will have to file, leave the country, come back, then you will get your I-94. And then you can start working. Okay?
Okay. Yeah. Presently I can work, right, on receipt?
Yes, if you file before October 10, it reaches there. As soon as it reaches there, you can start working for Company B. Let's call it Company B. Okay?
Okay. Yeah. Thanks.
Okay.
Thanks a lot.
Good luck to you. Good luck to you. Thank you so much for calling. These were very, very good questions because a lot of people get confused how it works. So you have to understand the concept of status and how it moves to another one. So if you need help, 510-742-5887. And today we are live on air. I have Michael with me, and the date is September 27, 2018. We are coming close to the October 1st. And we were talking earlier, before I take the other callers, Michael, let me just cover a little bit this H4 EAD issue because I get hundreds of questions on this. What will happen? What is next? What is next? Well, there are only so much we can speculate, but we can base it on other situations. So we are thinking that those who have it will be able to keep it, but won't be able to renew it. And if it gets some kind of situation where the H1 is denied, then the H4 gets cut off, then you lose it, you might not be able to reapply for it. So all these things can become a major, major headache, and that's why you're seeing so many networks picking up the story because a lot of people are living in fear right now. I have people calling me. Pretty much that's becoming the daily thing. most of the callers are calling me. They are very fearful what's happening. Now we have the NTA issued, but at least this one, it seems we can put that on the side for employment base, and cases like VAWA, etc. But for other cases, if you get denied, so they might put you directly on deportation. But they also say, based on that news that they publish on their website, that they will at least give you some time, which is good. We were thinking they will just issue it like that. So let's get ready for all this. Many things happening, but luckily we are fighting back and we are able to still get approvals, especially people who qualify for EB1. We highly recommend that you give us a call. We'll do an assessment, Sharif and I, and the number to our office, 510-742-5887. Just to let you know, EB1, you can just get. Don't think you don't qualify for it until we kind of analyze it, or a good lawyer analyze it. You might be surprised. You might be qualified for it. So I think I can take another caller right now, Michael. This is you 11 here. Hello.
Hi, Shah. Thanks for taking my call.
You're welcome.
I have a quick question regarding the amendment along with the extension filing. Currently, I'm in San Jose and I have the visa extension till 2019 October. But recently, my company filed amendment along with the extension for the different location. And as you know, there is no premium processing now. It may take 4 to 6 months. But by that time, if I change my plan to stay back at the current location, do I need to do anything, or it's okay? I can still continue with my current visa.
You can still continue with your current visa. As long as the previous visa has not been canceled, that means you still can. Let's say, for example, you're working with client A, okay? And then you have to move to client B, right? And then you decide, no, client A still needs me. You don't have to refile anything because the H-1B for client A is still good. As long as it has not been revoked by withdrawn by your company, your employer, you're fine. Okay, so there's nothing to do. Yeah, go ahead.
Yeah, so this is not with the clients, with the same company, so I think it's fine. The second question is, now actually my extension is due for the next year, so whatever they did with amendment, can I still use that I-797, or should I initiate again for whenever it is due again?
I didn't get your question. You don't need to redo. You don't need to redo that, right?
Oh, okay. So do I need to tell USCIS or like something like that if I'm staying back, or it's okay to continue? Like
No. You can elect. That means you can pick which one, because both are good. You can go and work at the amendment side, or you can just sit with the non-amendment side, amended side. However, there's an issue on your case which I'm a little bit tricky. You said they file an extension for you and an amendment. Yes, they can file an amendment, but an extension is too early. It won't be accepted, because unless you're very lucky. Usually an extension can only be filed 6 months before the H-1B expires. So it might have been too early to file the extension, but it's okay. They filed it. It's not going to hurt you, but I don't think they will approve that one. Okay?
Okay. Thank you, Shah.
Good luck to you. Good luck.
Thank you.
So you're welcome. So, ladies and gentlemen, this is Attorney Shah Parali from the Shah Parali Law. Our website is attorneyonair.com, attorneyonair.com. You can contact our office, 510-742-5887. And anything I'm telling you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Do we have more callers, Michael? Let me take callers and then we'll do. This is Shah Parali. You're live in air.
Hi, Shah. This is Rahul.
Hi, Rahul. How are you?
I'm good, thanks. Hey, thanks for taking the calls and helping us, Shah. Really appreciate it.
Oh, thank you so much for. I'm trying my best, because I've been down.
Helping us, all these 10 people, we get some relief when we talk to you guys.
Oh, thank you so much. Go ahead. What can I do for you?
Shah, my return will be maxed out in 6 years. For 6 years, maxed out in November. Okay. And my company and my 797 expired in July. My company filed for an extension until asking for he's eligible for November. Now what happened in September is I got my I-140 approved, and they recently filed another extension for 3 years.
Okay.
Since USCIS goes, they adjudicate it case by case. now let's say the first officer who looks at my first extension that was filed in June, asking till November 20th, if he looks at my case in December, would he approve it, or what would he do with my case? Because we are only asking him until November 15th, and it's already past November based on the current processing times. And
I got you.
Would he approve it or would he deny it? If deny, would my second extension that is filed come into picture, or what would happen?
Okay. First of all, since you filed the two and you did the right thing, one will piggy right on the other. So as long as one of them is pending, you're kind of safe. You are in what we call a period of authorized stay. So that means, let's say in December, for whatever reason, the officer doesn't look at the second extension. They say, oh, we're denying the first one. Then the second one, since it was filed before the first one was denied, you can rely on it to continue.
Oh, okay.
However, there's a big chance they will do both together. So be ready for that one, because that one can be denied for other reasons, okay? But if it is just a denial on the first one and the second one still pending, whichever is pending will protect you here, okay? So, and if you get a situation like that, give me a call at the office. I'll guide you in more details, because on the radio it's kind of hard to give you ideas.
Oh, yeah, sure. I know you, sir. I spoke to you once back in 2013.
Yeah,
I even met you.
I remember your voice, though. That's why I was thinking I know you. So, no, right now you can count on the second one. You should be okay.
Okay. So let's say if even the second one is denied in February, do I have to go back to country, or is there a way we could just change of status? Because my wife is on H1 too, and can I just change my status, or it doesn't work that way?
You cannot do change of status. What you need to do in this case, you need to just quickly leave the country, go to Mexico or something, get an H4 stamp, come back, and then reapply for the H1, moving from the H4 to the H1. And by that time, hopefully, premium will be back. You should be okay.
Right.
So if you don't feel comfortable of your case being approved, you can also do another thing. Does your wife has an I-140 approved?
Yeah.
Does she have an I-140 approved? Okay. So what you need to do, you can already right now, since H4 EAD is still there, you might be able to apply for it and keep it pending on the side. That will allow you, even if both H1B gets denied, you can rely on the H4 situation and you don't have to leave the country. And plus, since you file it now, we are hoping those who file now, they will be able to get their H4 EAD. So those are kind of tricks you can use, but these are not bad. I'm using the word tricks. It's not really tricks. It's strategy, right? So there are many...
No, that's why we are here. That's right, yeah.
So, yeah, you can do that too, because it can go in parallel. And then if the H1 gets approved and you don't want to continue with the H4, you can always withdraw the H4.
But how can I keep it pending? Let's say if I file my change of status now, will I be able to find out my change of status, because my status already expired? I'm just in authorized stay.
Oh, it's already expired in July.
Yeah, my 797 expired in July, but I'm just in authorized stay. Will I be able to file now or no?
Yeah, you can file using what we call the bridge, but it's not really a good idea. So don't do that. Just leave it on the side, because that's why, in quick answers, sometimes I leave that part, but. So, no, it's not a good idea to file it, even though it is possible, using kind of stating that there's a pending H1 extension for you, and based on that H1, you should be able to continue on this. And you filed did you file it in the premium?
No, Shah, what happened was there was a change in address, and my company denied doing it in premium. See, the problem is September 11th they took out premium, and September 10th is when I got my...
Oh. I'm sorry to hear that. But you said they changed address, so the extension will not be perfect. And is it going to Nebraska? Do you know?
No, they went to California Service Center. Both of them.
Then. Forget about it. Just stick to that one. And if there's any problem, give me a call at the office.
For sure. Finally, before you go, there's one thing I want to clarify. So I have heard people saying that you can, your company can send a letter to USCIS saying that. So basically, they are saying that for the first receipt number, you can attach your second receipt number. Is that a way to do it, or is it just false?
What you mean, to do the extension based on the I-140?
Yeah, no. What they're saying is, so I have my first extension, right? For that is filed in July. So they are saying that write an email to USCIS saying with the first receipt number, saying that you have a second extension that is filed, and maybe they can look at both the cases. Yeah, it's called consolidation. Yeah, you can request that. But email, you cannot do it. Your company can do that. But yeah, you can request that. If it wasn't the premium, it would have been easier. You could have just used a premium email. But yes, you can do that and request that they consolidate the two. But they will actually eventually, because the receipt number will pop up all the applications. But yeah, you can always send that email. I don't know if it will work, but yeah, you can send it. Okay. No, but when you say that they can already do it, but how will they know that I have a second one filed? When my first one is so let's say you are an USCIS officer looking at my case today. Man, you're a computer engineer. Everything is as soon as the case goes in there, it will punch in and match your name, right? So when he's looking at your file, it's not physical file. He will be looking at it on the computer. So the two will match, right? It's like you have a fingerprint. Let's say someone does something in Arkansas and does it in California, and if the FBI is looking, they're not looking only at one. Both will pop up because it's the same name, it's same. So they always ask for things, but they do have access to it. But yeah, of course, they can pretend they didn't see it, but technically they do see it. Okay. Okay. Good luck to you. Wish you all the best. But send the email. It's a good idea. Okay? Good luck, and if you need help, let me know. I'll contact you back. Thanks. Okay, thank you. 510-742-5887, website attorneyonair.com. And again, you can also add to our YouTube channel, youtube.com/Sharperari-Law. Let me take another caller, Michael. Sharperari, you're live on air.
Good morning, Shah. I have a quick question about an H4 EAD. H4 visa stamping.
Yes.
So I'm on H1, and my 6th year is it's ending on December 2018 this year. My I-140 is already in process, so I'll file my extension once it's approved. My wife, H4, it's already expired, and she is in India now. So if I get my H1 extension approved, can she just go for stamping based on that H1 extension, or do I still need to file I-539 for her?
No, not at all. Okay, first of all, this is a very excellent question because it's very confusing. A lot of people get confused. For H4, there's no need at all to do anything here. You do the I-539 when you want to extend it when your wife is present in the U.S. Since your wife is already outside, all she has to do once you get approval, you take that approval with her marriage certificate and proof of marriage. She goes there, she will get her stamp because it's done directly by the State Department of State, which is basically the U.S. Embassy. The H4 doesn't work like the H1, where you have to have the first an approval with the USCIS, which is the Department of Homeland Security, then you take it for stamping. H4 works directly from the source of the H1, so you don't have to worry about the I-539 because there's no I-539 when you're outside the U.S., so there's no need for that, okay?
And also, is there going to be any question about why my H1 expiration date and her H4 expiration date was out of sync? Because I never filed I-539 for her. I wasn't aware that there is an I-539 when she was here. But by the time I learned about I-539, it was already too late for me to file extension for her while she was here. So now she's in India. So as you said that I can just go for stamping once I get my I-797 with her, with all the marriage certificate and all the documents. But
now
is there going to be a question about...
You mean when you file an H1B for you, you mean she was not an H4, so H4 was already expired and you didn't file an extension? What's the deal?
So I changed my employer about a year back or so.
Oh, okay. I got you.
And at that time, her H4 and my H1 got out of sync. So I checked the status online. Like my previous employer didn't revoke my H4. Sorry, my H1. So her H4 was still valid and everything was fine.
Okay.
I thought that I'll get the extension on time before her status expires, but that wasn't the case. So now she's in India, and I'm still in process of filing my extension.
How many days she stayed out of status?
As far as I know, she been to India before her status expired.
Okay. This is a very good point you brought up. One of the things many people do, and it's a mistake, is whenever you file a transfer, always file an I-539 because the H4 is attached to the previous H1. But if you file the I-539, it moves, right? In your case, you're very lucky your employer didn't cancel the H1, which means the H4 was still good when she left, so it won't affect her then, okay?
Okay, thank you.
Okay, good luck to you, And I think, Michael, I will not be taking calls right now. I just want to, I'll take maybe one more call, but let me just finish a little bit another topic because we've been talking a lot about immigration, but this is another thing. I'm getting a lot of calls, people who are very worried, and if their case gets denied, do they leave the country? What happened to their houses? What happened to their credit cards? What happened to, et cetera, And I know you're already under stress. Now you have another stress. So just to let you know, Michael, I won't be taking more callers now. For those who want to call, please call us for consultation at the office, 510-742-5887, or call us next week on the radio if you get a chance. So now I was talking about this situation where a lot of people are unfortunately having to go back. Not go back permanently, but even temporarily because there's no premium. Like, for example, you get terminated and you pass the grace period and you find another job maybe down the road, like 1 or 2 days after. You cannot file a transfer at this point. Then you have to file a new employment, etc., and you have to wait in India. So many of them, because of that situation, they are getting worried and they have debts, they have houses, etc. What do? First of all, your house, you don't lose it, even if you lose status, okay? I just want to repeat that. You don't lose your house in most states because those are ruled by state laws and the states really care about their residents and etc. So don't panic and you have to sell. But if you want to negotiate on your loans, etc., especially on your second mortgage and the house value has gone down, we can help you negotiate those loans. And if you have credit cards, because many people now use the plastic credit cards, and suddenly with losing their jobs, they can't afford to pay it, but they still have a little lump sum on the side. They want to just get rid of that debt because they don't want to have a huge bad credit when they come back. So what we can do, we can actually settle those debts. We can negotiate them, we can deal with them, and so it's not really possible that so we can actually help you. So we are in a situation where we have to deal with people who are basically stressed with a lot of loans, etc. So we can help them. We have to make sure that the people can get rid of their debts. So it's really a very sad situation, but we can help you at least ease it with your debts. We can deal with those debts, etc., etc. So unfortunately, things are doing really are getting tough out there. And a lot of people are faced with difficulties. So we can do a debt settlement for you. And you can check yourdebtsettlementattorney.com, yourdebtsettlementattorney.com if you want more details. So, ladies and gentlemen, if you need help, of course, either immigration or debt settlement, we are here for you. And the number to call is 510-742-5887. So let me recap today because there are many things, so many things that is happening. It is really heartbreaking what we are seeing right now. Number one, we are seeing that NTA issues, which is becoming more and more a problem. It is not really kind of easy on many people right now because we are having many people calling us and desperate. They don't know exactly what to do, and many of them are taking the wrong route too. So, for example, a lot of people are jumping on CPT without realizing that it can actually backfire on you down the road. CPT is not meant to be a work permit, although it works like a work permit. So it's not really an option. You should not look in the short term for quick solutions sometimes, because quick solutions can end up by creating a lot of problems. If you look now at the RFEs that came from the USCIS, people who have used CPTs on day one, lots of questions. Although it's legal, it is a problem sometimes, and they have to explain how it is incorporated, or it is basically not incorporated, but it's an integral part of their study. And number two, RFEs, we are seeing a lot of people dealing with many issues like issues of changing employment, and they have no choice because their company wants to file it. The new company wants to file a transfer and want them to move with them, and usually we will tell people wait on the answer first, then move. But now with no premium, is becoming an issue. So to recap today, ladies and gentlemen, first the H4 EAD. There is a chance within the next 2-3 months we are going to really see a total rollback of the H4 EAD. But again, there might be lawsuit, like I said, or we might not see anything. It might just be something they are saying right now just to appease the lawsuit of Safe Job USA. But Safe Job USA is putting a lot of pressure. They are being backed by many anti-immigration groups, etc., etc. So this is their call, and it's a lawsuit, so we have to respect what the court says. But at the same time, hopefully there will be counter lawsuits which will fight this. Now, the second thing, the NTAs, if you look at the publication, I think yesterday, that on October 1st they're going to start issuing those NTAs. But luckily, it seems of employment base is not going to happen, and humanitarian ground, it won't happen. However, cases like marriage petitions, parent petitions, if you have a denial, it might create problems because they will be placed in deportation. So I will recommend that you file your case with a lawyer now, because, or someone who has, not all, because there's no other apart from lawyers who can do this. Make sure that you know what you're doing, and the lawyer also knows what he's doing or she is doing, and make sure that it is done properly. And if you need help with those petitions too, give us a call, 510-742-5887. And as I was mentioning earlier, there are many things that we will see happening, and unfortunately, it's not really going to be easy. So get ready for the tough times, but we hopefully will make it through. So if you need help, again, 510-742-5887. So if anything I'm telling you today is for educational purposes only, you should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And again, the website to check, attorneyonair.com, and please subscribe to our YouTube channel, youtube.com/Shah Pirali Law. Shah Pirali Law, not Pirali Law, but Shah Pirali Law. Please check that and let us know if you need help. Thank you. We'll be back next week. Amit, are you there?
Hey, Shayad, how are you?
I'm doing well.